December 23, 1944. 900 hours. A German SS officer stands on a snow-covered ridge in Belgium and watches an unarmed priest kneel over a dying American soldier. He sees the white cross on the helmet. He sees both hands occupied holding a photograph. He gives the order. 1 shot. And then he walks away. 11 minutes later, 3 American soldiers find the body still clutching the photograph in the snow. 31 miles to the west, that report lands on George Patton's map table, in the middle of the most complex military operation of his career. And Patton does something nobody in that tent expected. He folds the report, puts it in his breast pocket, and says 2 words. "Get me a Jeep." Don't forget to hit like, subscribe, and turn on notifications so you never miss what's coming next. Join us as we go deeper into the stories, events, and moments from history that still have something to say to the world today. What happened next, inside a prisoner-holding tent in the Belgian countryside, is not in any official military document. It is in one man's diary. 1 paragraph. Written 2 days after the fact by an aide who was still trying to make sense of what he had witnessed. And what that paragraph describes is one of the most quietly devastating confrontations of the entire Second World War. Not a battle. Not an ambush. 2 men standing 3 feet apart in a canvas tent while a stove ticked and snow fell outside, and the entire question of what civilization is and what it costs playing out between them in under 5 minutes. This is the story of Father Brendan Sheehan, SS Hauptsturmführer Karl Brenner, and the 40 seconds that George Patton stood completely still while a war criminal held out a copy of the Geneva Convention and told him exactly why the law was on his side. He was right. That is what makes this story worth telling. Father Brendan Sheehan was 38 years old on December 23, 1944. He was from Cork, Ireland. He had a parish before the war. Small stone church, 200 families, the kind of community where he knew every face and most of the dogs by name. He was not a soldier. He was not a tactician. He was not a man who studied maps or understood armor formations or could tell you the range of an 88mm gun. What he understood was this: men were dying in foreign fields without a priest beside them, and that was a problem he could personally do something about. In 1942, he volunteered. Nobody asked him. There was no campaign to recruit clergy. He simply presented himself to the army and made his case, and the army, which by 1942 had learned that unit cohesion and morale were as lethal as any weapon, agreed. They gave him a uniform, a helmet with a white cross painted on the front, and assigned him to the 90th Infantry Division, which had been in continuous combat since the beaches of Normandy in June of 1944. No, he carried no weapon. He was offered a sidearm 3 times by 3 different officers who genuinely could not understand why a man walking into active combat zones would refuse it. His answer was the same every time: if he was holding a weapon, he was not doing his job. His job was to be present at the moment when presence was the only thing that mattered, when a man was moving from one side of whatever line divides the living from the dead to the other. And the only thing left to give him was your full attention and the words that a priest says at that specific threshold. The men in the 90th knew his face the way they knew their own sergeants. When Sheehan appeared beside you in the field, it meant one of 2 things: either you were about to leave this world, or someone near you already had. Either way, the most important thing was being handled. That knowledge, that specific piece of certainty in the middle of everything that was uncertain, did something for fighting men that no training could produce, and no order from above could replicate. Getty. By the morning of December 23, 1944, he had been awake for 31 hours. He had administered last rites to 7 men since dawn. 4 in a collapsed farmhouse outside Sauerlautern. 2 in a ditch along the road east. 1 in the back of a medical half-track that kept moving while he worked. He had blood on his sleeve that was not his own, and had stopped noticing it somewhere around the 5th hour. When a runner reached him with word that Sergeant Thomas Greer had taken a round through the lower abdomen and could not be moved. Sheehan was already back on his feet. Thomas Greer was 24 years old. He was from Macon, Georgia. He had a photograph of his mother in his breast pocket and had been asking for it since the round hit him. Greer was alive when Sheehan reached him. Barely. The kind of alive that is doing everything it can and losing anyway, each breath shallower than the one before. The ravine was 2 miles east of Sauerlautern. To reach it, Sheehan walked 200 yards of open ground. The snow was ankle deep. His white cross was visible the entire distance to anyone on the surrounding high ground who cared to look. He was not running. He was not crouching. He was walking at the pace of a man who understood that if he ran, he would arrive afraid. And being afraid when you knelt beside a dying man was the one thing that could make this moment worse for the person it was supposed to be for. He reached Greer. He knelt in the snow. He found the photograph without being told where it was. He held it where Greer could see it, and put both his hands on the man's chest, and began to speak quietly, and Greer's eyes fixed on his face the way a drowning man fixes on something solid above the waterline. That is when the 4 SS soldiers came over the ridge to the north. And they came fast, boots punching through the snow crust, rifles up, moving in a tactical line the way men move when they are well trained and completely certain of what they are. They saw the ravine. They saw the American soldier on the ground. They saw the man kneeling over him. No weapon. Both hands occupied. White cross on the helmet, bright against the gray December sky, visible and unmistakable at 40 feet. They stopped. Karl Brenner stepped forward from the ridgeline. He was 34 years old. He wore the rank of an SS Hauptsturmführer. He had spent 2 years on the Eastern Front before being transferred west in October. He had the particular stillness of a man who has been in continuous combat long enough that violence no longer registers as an event. It registers as weather, something that simply happens, something you move through. He looked at Sheehan for 3 seconds. He looked at the cross. He gave the order. 2 soldiers came down the slope. Sheehan heard them and turned. He saw the collar insignia. He saw the rifles. He did not run. He turned back to Greer. He put his hand on the side of the man's face and said the Latin words quickly, the words that a priest says when there is almost no time left. And the most important thing is that they are said before the time runs out entirely. The soldiers grabbed his shoulder and hauled him to his feet. His Bible went into the snow. The photograph went with it. Sheehan found his footing. He looked at the soldier holding him. He looked at Brenner on the ridge. He looked back down at Greer, still breathing, eyes open, watching what was happening to the priest who had been beside him 10 seconds ago. Brenner said something. 1 sentence. The soldier holding Sheehan stepped back. The other raised his rifle. Sheehan was looking at Greer when it happened, not at the rifle, not at Brenner, at Greer, making sure the last thing he gave the man was his full attention. The photograph was in the snow beside him when the 3 American soldiers arrived 11 minutes later. His left hand was resting on it. Corporal Dennis Falk wrote his sworn statement for the Judge Advocate General's file 3 days later. 2 pages pencil on standard Army stationery, factual throughout, precise. Then the final paragraph. The handwriting changed. Looser. The letters not quite tracking the ruled lines. He wrote that Sheehan was still holding the picture when they found him, that he didn't know if the priest had picked it up after, or had never let go, and that he kept thinking about it, and didn't know why it mattered, but it did. And Captain William Harkins read that paragraph and did not edit it. He said later, it was the most important sentence in the entire 34-page document. The report reached Patton at 1340 hours. He was at his forward command post 31 miles west, standing over a map table with his corps commanders executing the movement that would relieve Bastogne in 48 hours. The table was covered in grease pencil markings. 3 phones were being answered in rotation. The Third Army was consuming every decision he could produce and demanding more. Harkins came through the tent entrance and waited. Patton looked up. Harkins handed him the report without speaking. He had learned in 2 years beside this man that there were moments when summary was an insult to the content. Patton read it once. He did not go back. He set it on the corner of the map table. His face had not moved. His hands were still. Then he said, "Who has the prisoner?" The 12th Corps holding area was a requisitioned farm 6 miles behind the front. 3 large canvas tents behind the main stone farmhouse. Wooden benches along the walls. Iron stoves in the center. 2 MPs at each entrance. Patton's jeep came through the gate at 15:17 hours. He walked straight past the farmhouse, straight to the tents. The MPs at the entrance of the second tent registered the stars on the helmet and separated before he reached them. 15 German prisoners sat on the benches inside, mostly infantry and support, a mix of ages, sitting with the particular stillness of men who have stopped being soldiers and not yet figured out what they are instead. Brenner was at the far end of the left bench. His SS collar tabs had been removed during processing. Standard procedure, but the posture was still there. Chin level, back straight, eyes forward. The bearing of a man who had spent years being the most dangerous thing in any room he entered. He looked at Patton without looking away. Patton walked the full length of the tent and stopped in front of him. The stove ticked. The canvas moved in the wind. Nobody in that tent made a sound. He said in German, "Stand up." Brenner stood, not quickly, with the slow, deliberate rise of a man who has decided to comply and is making sure everyone in the room understands the decision was his. Patton laid out what he knew. The priest, the cross, both hands occupied, unarmed. The order Brenner gave from the ridge. Brenner said nothing. Then he reached into his breast pocket. Why? He produced a folded document. He held it out toward Patton. It was a printed copy of the 1929 Geneva Convention in German, folded open to the prisoner of war articles. He had obtained it before his capture. He had carried it deliberately into surrender. He had kept it through processing. He had held it in that tent for 4 hours, waiting for exactly this moment, and then he spoke fluently, completely without hesitation. He cited Article 4. He cited the protections owed to captured combatants who had surrendered in good faith. He said, coercive interrogation beyond name rank and service number was explicitly prohibited. He said the United States government had signed the convention and he expected every provision honored in full. The words came out flat and prepared, slightly different from the rhythm of natural speech. He had rehearsed this. He had anticipated this conversation and prepared for it the way a lawyer prepares for the one question he knows is coming. He was right. That is the thing that has to be said plainly. He was legally, precisely, completely correct. The Geneva Convention of 1929 was a 97-article international agreement signed by 47 nations. It established binding standards for the treatment of prisoners of war, and it contained no conduct clause. No provision that read a soldier who violated these protections before capture thereby forfeits them after capture. The law did not ask what you had done on the Eastern Front for 2 years. It did not ask what order you gave in a ravine at 0900 that morning. It asked only, are you a captured combatant who surrendered in the context of armed conflict? No. Brenner was. The convention covered him, fully, without reservation. He had found the gap between what the law protected and what it punished. He had stepped into it, and the expression on his face said he had been waiting to be right about something in this tent since the moment his hands went up that morning. Harkins counted what came next. He said 40 seconds of complete stillness passed. For a man who had reorganized an entire army's axis of advance in 48 hours, 40 seconds of silence was geological time. Then Patton said, "You've read it, all of it. All the articles on protected persons, chaplains, medical personnel, wounded soldiers who have stopped fighting. You read those articles before December 23rd. Not after, before. You read every word about what the cross on that helmet meant under international law, and then you went to that ravine and gave the order anyway." Brenner's hand remained extended. The document remained offered. The math did not change. Patton looked from the document to his face. He held the look for a long time. Then he said quietly, "Put it away." Something in the voice made Brenner's hand come down. Patton turned to Harkins. He gave the order for a full war crimes file. The field report, the medical examiner's findings. Every witness statement, the tactical map showing Brenner's unit position. Surrender documentation, confirming rank and command authority. Complete before the week ended. Nothing missing. Nothing summarized. Then he turned back to Brenner. He said, "The convention protects you. Every article, every provision. You will be fed correctly. You will be housed correctly. You will not be touched. No one in this army will lay a hand on you. You have my word, and my word is the same thing as an order in the Third Army." He paused. "And when the war is over, when Germany has surrendered, and the lawyers have assembled, and the tribunal has sat down with that 34-page file and read every word of every statement from every man who stood in that ravine, the convention will not be in the room. It will have done its job. It will have gotten you to the courtroom alive and intact, and with every right you were entitled to. And then it steps aside. And what's left in the room is the evidence, the witnesses, the medical examiner's report, and the name on the cross they put over his grave." He reached into his breast pocket, took out the field report, unfolded it once, looked at the name at the top. Father Brendan Sheehan. He folded it, put it back. He said nothing else. He walked out of the tent. Outside, the snow was still falling. At the jeep, he stopped with one hand on the doorframe and looked back at the tent, at the snow coming down across the holding area in a curtain that erased everything beyond 60 yards. He stood there long enough that Harkins began to wonder whether to speak. Then Patton said to no one in a voice low enough that Harkins had to reconstruct it later from partial hearing and context. He carried a piece of paper to protect himself from the same law he didn't bother to read when it was protecting someone else. He got in. Back to the command post. We have a corridor to finish. Here is what that moment leaves behind, and why it matters more now than it did in December 1944, when the snow was falling, and 3 soldiers found a priest's hand resting on a photograph in a Belgian ravine. Patton did the correct thing. Not the satisfying thing. The correct thing. He protected a man he had every personal reason to destroy. He filed the paperwork. He honored the law. He understood something that most people only understand in the abstract. A civilization that applies its rules selectively only to those who deserve them. Only to those who honored them first does not have rules. It has preferences. And preferences are not law. Preferences are power wearing a costume. But the same convention that covered Brenner completely did not reach Father Brendan Sheehan in time. The same 47 signatures. The same 97 articles. It arrived in that ravine 11 minutes late in the form of 3 soldiers who were 20 years old and not ready for what they found. In Part 2, we go inside the War Crimes Tribunal process itself, the 34-page file that Harkins delivered personally and stood at the desk until it was logged and receipted, and the question that every prosecutor who opened that file had to answer before they could move forward. When a man invokes the law only in the direction that benefits him, is honoring that law an act of justice? Or is it simply the price a civilization agrees to pay in order to remain a civilization at all? The answer they arrived at will surprise you, and it will not make you feel better. In Part 1, we watched an unarmed priest walk 200 yards of open ground to kneel beside a dying man in a Belgian ravine. We watched an SS officer give an order. We watched George Patton drive 31 miles to stand in a canvas tent and tell a war criminal that the law would protect him all the way to the courtroom, and then step aside. Patton filed the paperwork. He honored the convention. He did the correct thing. But here is what we did not answer. Here is what kept Captain Harkins awake for 2 days after that tent, a 34-page war crimes file had been delivered to the Judge Advocate General's office. Logged, receipted, now sitting on a desk inside a legal system that had never prosecuted a case quite like this one. Because Brenner had not made a mistake. He had not panicked. He had not acted in confusion. He had read the law, understood exactly who it protected, and given the order anyway. How do you prosecute a man who knew the rules and broke them deliberately? How do you build a case when the defendant understands the legal framework better than most of the lawyers in the room? 31 JAG officers across the Allied legal apparatus were about to find out. And what they discovered would shake the foundation of every war crimes prosecution that followed for the next 50 years. The Judge Advocate General's office in January 1945 was not a quiet place. 12 officers assigned to Western European war crimes documentation, 140 open files, new material arriving every week as the Reich collapsed, and the record of what had happened in the fields and the farmhouses and the ravines came into the light. The system was enormous, and it was moving slowly. And it was moving slowly because the law itself had not caught up to the scale of what it was being asked to judge. Major Arthur Colby was 37 years old. He had been a federal prosecutor in Chicago before the war. He had handled homicide fraud conspiracy. He understood evidence, and he understood argument, and he understood the specific way that a prepared defendant could use a legal framework as a weapon against the very system built to hold him accountable. He read Brenner's file in one sitting. He read the field report. He read Falk's statement, including the final paragraph about the photograph. He read the medical examiner's findings. He read the tactical map showing Brenner's position on that ridge. The sightlines confirmed the distance, measured the white cross on the helmet visible at 40 feet, with no obstructions between the ridge and the ravine. Then he read Brenner's surrender documentation. Rank confirmed. Command authority confirmed. The 4 soldiers on the ridge were his men. The order came from him. He sat back and said to the officer across the desk from him, "The problem is not the evidence. The evidence is perfect. The problem is the argument he is going to make the moment he stands up in that room." This because Brenner's argument was already written. He had written it in the holding tent on December 23rd, when he pulled the folded convention out of his breast pocket. And the argument was this: the Geneva Convention of 1929 established legal protections for categories of persons in wartime. It was signed by both Germany and the United States. It was binding on both parties. He, Karl Brenner, had surrendered correctly, been processed correctly, and was entitled under that same instrument to humane treatment, adequate provisions, and protection from coercive legal proceedings. The SS did not teach the Geneva Convention as binding law. It taught it as evidence of weakness. And Brenner had learned both lessons simultaneously, learned the enemy's rules well enough to use them and discard them completely when the enemy cannot enforce them. He had found the gap between what the law protected and what it punished, and now he was going to stand in the gap and make the tribunal prove it was wrong. Colby needed an argument that did not fight the convention. Fighting the convention meant fighting the same instrument that protected every Allied POW in German hands. That was not a fight anyone in that room was authorized to have. He needed something else. He found it in a 40-page legal memo written in 1943 by a British international law professor named Harold Lauterpacht, which had been circulating in Allied legal circles for 18 months and which almost nobody had read because it was 40 pages long and there was a war on. Lauterpacht's argument was precise and it was radical for its time. He wrote that the Geneva Convention established minimum floors for the treatment of protected persons. It did not establish ceilings for the prosecution of crimes committed against those persons. The Convention's silence on pre-capture conduct was not a shield. It was simply silence. And silence in a legal instrument did not mean permission. It meant the question had not yet been answered, and the appropriate authority for answering it was a tribunal constituted for exactly that purpose. Colby read that paragraph 3 times. Then he wrote to London and requested Lauterpacht by name. Harold Lauterpacht arrived at the JAG office on February 4, 1945. He was 51 years old. He had a Viennese accent and a briefcase that appeared to contain every document he had ever written, and the documents of several other people as well. He sat across from Colby and said, "You have 34 pages. How many witnesses?" 9 confirmed available. More being located. Medical examiner. Complete findings. The wounds, the distance, the angle. Everything consistent with the witness accounts. His rank and command authority are confirmed in his own surrender documentation. He signed it himself. Lauterpacht set his briefcase on the table. Then the convention is not your problem. The convention got him to this room. Now we do something the convention was never designed to stop. And the legal theory they built together over the next 6 weeks was not complicated. It was precise. The Geneva Convention protected Brenner as a prisoner of war. It said nothing about his liability for crimes committed before capture. Those crimes fell under a separate body of law, the laws and customs of war, as codified across decades of international practice and as recognized by the Hague Conventions of 1899 and 1907, which both Germany and the United States had also signed. Under those instruments, the deliberate killing of a protected person, a chaplain clearly identified as such performing clearly protected functions by a military officer who had read and understood those protections, was not a gap in the law. It was a crime for which the law had words, and the words were willful killing of a protected person. A war crime under any framework in any language, signed by any nation that had put a name on that document. Brenner had carried the Geneva Convention into the holding tent as a shield. Lauterpacht and Colby were going to hand him a copy of the Hague Convention and tell him he had been holding the wrong document. The case file was formally presented to the Allied Tribunal framework on March 3, 1945. 34 pages from Harkins, 40 pages from Lauterpacht, 9 witness statements, medical examiner findings, tactical maps, surrender documentation signed by the defendant. The argument was complete. The theory was sound. The evidence was, as Colby had said, in January, perfect. But there was a problem nobody had anticipated. By March of 1945, the Allied advance had accelerated past every projected timeline. Germany was collapsing faster than the legal apparatus could process the cases piling up in front of it. New files were arriving at a rate that exceeded the capacity of the tribunal system by a factor the JAG officers had stopped calculating because calculating it was demoralizing. The Brenner file was complete and correct and ready to proceed. And it was number 47 in a queue that was growing longer every week. Not every file reached a verdict. The system was not designed to be perfect. It was designed to take the evidence, apply a legal standard, and produce a record. Some of those records reached courtrooms, some did not. The machinery was vast, and it moved against a mountain that kept growing until the mountain was the size of everything that had happened in every field and ravine and farmhouse across 6 years of industrialized violence on a continental scale. What happened to Brenner's specific file after March 3, 1945, is part of that record. The record exists. It is in the archives. It is not the subject of this story because this story is not about whether one SS officer stood in a courtroom. It is about what Patton understood in that tent, and what it cost, and whether the cost was worth paying. Colby wrote in his personal diary on March 4th, the day after the file was submitted, a single sentence that Lauterpacht quoted years later in a lecture at Cambridge. He wrote, "The law is not fast enough for the crimes committed against it, but it is the only instrument we have that might be faster than forgetting." Father Brendan Sheehan was buried at Henri Chapelle on December 26, 1944. White Latin cross, section 5, row 11, the same shape as the one on his helmet. Thomas Greer survived. He went home to Macon, Georgia. He never spoke publicly about the ravine. His wife wrote down what he told her the night before their daughter's baptism in 1951 about the photograph, about the Latin words he hadn't understood, but had heard clearly about the way Sheehan turned back to look at him in the last seconds he had. She kept the paper in the back of a Bible for 40 years. And here is where Part 2 leaves us, and why what comes next in Part 3 is the question that none of them could close. The legal framework that Colby and Lauterpacht built, the argument that a man's pre-capture conduct was not shielded by the protections extended to him after capture, did not stay inside the Brenner file. It traveled. It was cited. It was argued and refined. And eventually it became part of the foundation of something much larger, something being built simultaneously in a courtroom in Nuremberg, where a different set of lawyers were trying to answer a different but related question about whether entire systems of organized violence could be prosecuted under international law, and what evidence you needed, and what argument you made when the defendant's answer was that he was following orders. Shouted. The Brenner argument and the Nuremberg argument were not the same argument, but they needed each other. And the man who understood why was not Kolbe and not Lauterpacht. He was a Polish Jewish lawyer who had lost 49 members of his family in the Holocaust, and who had been writing about this exact legal problem since 1933 before the war started, before anyone in a position of authority believed him. His name was Raphael Lemkin. And in Part 3, we find out what he was carrying in his briefcase when he walked into Nuremberg, and why the word he had invented in 1944 was about to change what international law meant forever. The crime had a name now, and the name changed everything. In Part 1, a priest walked into a ravine and did not walk out. In Part 2, two lawyers built a legal argument on 40 pages of international law and filed it into a system moving slower than the crimes it was trying to judge. The argument was sound, the evidence was complete. And then we left you with a name, Raphael Lemkin, a Polish Jewish lawyer who had lost 49 family members, a man who had been writing about this exact problem since 1933, a man carrying a word nobody had heard yet. That word was about to walk into Nuremberg and change what international law meant permanently. Nay. But before Lemkin and before Nuremberg, something else happened. Because while Kolbe and Lauterpacht were building their legal framework in a JAG office in February 1945, the war itself had not paused to wait for them. The Allied advance was accelerating, Germany was collapsing, and in the chaos of a regime coming apart at its foundations, the crimes being committed in the fields and the roads and the retreating columns were not decreasing, and they were increasing. Desperation produces a specific kind of violence, and the legal system was 30 files behind. In the spring of 1945, Allied military intelligence began tracking a pattern that JAG officers had started noticing in witness statements arriving from the front. As the Wehrmacht collapsed and SS units fell back under pressure, the targeting of protected persons was not stopping. It was concentrating. Chaplains, medics, wounded soldiers who had stopped fighting, the White Cross, the Red Cross, the raised hands. Analysts at the 12th Army Group Intelligence Section compiled the pattern in March 1945. The numbers were specific and they were damning. In the 6-week period from February 1st to March 15, 1945, confirmed incidents involving the killing or wounding of protected persons had increased by 63% compared to the same period in 1944. Not because more SS units were operating. Fewer were. Because the units still operating were doing so with the specific logic of men who had decided they were already lost and that the conventions therefore no longer applied to them. Then, they had read the same calculation Brenner had made in that ravine. They had reached the same conclusion. The cross on the helmet was not a legal category. It was tactical information. It told them who would not shoot back. The intelligence report landed on the desk of Brigadier General Edward Betts, the Judge Advocate General of the European Theater, on March 22, 1945. He read it and immediately understood the problem it created. The legal apparatus was already overloaded. The Brenner file was number 47 in the queue. And the pattern described in the intelligence report meant that 47 was going to become 470 before the war ended, and then the queue would become a mountain, and mountains did not produce verdicts. They produced archives. Betts called a meeting. 12 JAG officers. Kolbe was there. Lauterpacht was there as a civilian consultant. The question on the table was not whether the crimes were real. The question was whether the legal framework was fast enough to matter. It was Lauterpacht who said the thing that changed the direction of the conversation. He said, "The problem is not speed. The problem is architecture. You are trying to prosecute individual crimes inside a system designed for individual crimes. What is happening in those fields is not individual. It is systematic. It has commanders. It has orders. It has a chain of authorization that runs upward. If you follow that chain, you do not have 47 cases. You have one case with 47 exhibits. The room was quiet. Colby said, "You're talking about prosecuting the system itself." Lauterpacht said, "I am talking about prosecuting the people who built the system, the people who issued the orders that made the ravine possible." Brenner pulled a trigger. Someone above Brenner created the environment in which pulling that trigger was not only permitted, but expected. Schalte. This was not a new idea. Lauterpacht had been writing about it since 1943. But in March 1945, with the Reich collapsing and the evidence accumulating at a rate no individual prosecution process could absorb, it was suddenly an idea whose moment had arrived. And that is where Raphael Lemkin enters the room. Lemkin had been trying to get people to listen to him since 1933, when he presented a paper to the League of Nations proposing that the systematic destruction of national ethnic or religious groups be recognized as an international crime. The League of Nations was not interested. The concept did not have a name yet. Without a name, it was hard to argue for a law against it. In 1944, Lemkin published a book called Axis Rule in Occupied Europe. In an 800-page legal analysis of Nazi occupation policy, he included a chapter introducing a new word. He constructed it from the Greek word for people or tribe and the Latin word for killing. He called it genocide. He defined it with precision. Genocide was not simply mass murder. It was the coordinated destruction of the essential foundations of the life of national groups with the aim of annihilating the groups themselves. It included physical destruction, but also cultural, religious, economic, and biological destruction. It was a crime of intent as much as of action. And crucially, it required commanders. It required policy. It required a chain of authorization, which meant it could be prosecuted at the top of that chain rather than one trigger at a time. When Lemkin walked into the preliminary Nuremberg planning sessions in the spring of 1945, he was carrying a copy of his book and a legal argument that had been waiting 12 years for a tribunal large enough to hear it. He found in Lauterpacht a lawyer who understood the architecture he was proposing. They disagreed on specifics significantly. Lauterpacht believed the focus should remain on crimes against individuals rather than groups, because groups could not be victims in the same legal sense that persons could. But they agreed on the fundamental point: what had happened in Europe was not a collection of individual war crimes. It was a system, and the law needed a word for the system. Nuremberg gave it one. Actually, it gave it two. The indictment at Nuremberg contained 4 counts. Count 3 was war crimes, in the traditional sense violations of the laws and customs of war, including the deliberate killing of protected persons. Count 4 was crimes against humanity, murder, extermination, enslavement, persecution on political, racial, or religious grounds committed against any civilian population. And Count 4 was new. It had never appeared in an international indictment before. It was the legal architecture that Lauterpacht and Lemkin had been building toward. The recognition that a system of organized violence directed at populations could be prosecuted at the level of the people who designed and authorized the system, not only the people who carried out individual acts within it. Brenner's case fed into this framework at Count 3. The deliberate killing of Father Brendan Sheehan, a protected person clearly identified as such by an officer who understood the protections and gave the order anyway, was exactly the kind of case Count 3 was built to prosecute. It was a war crime in the traditional sense, documented, witnessed, medically confirmed, and legally argued by Colby and Lauterpacht, with 34 pages of evidence and 40 pages of legal theory. But Count 4 reached higher, because Brenner was not the only SS officer who had given that kind of order. He was not even unusual. He was the documented version of a pattern that had been occurring across the Eastern Front for years, across occupied territories, across every theater where SS units operated under the operational assumption that protected persons were tactical information rather than legal categories. The people who created that operational assumption had names. They had ranks. They had offices. and in November 1945, 24 of them sat in a courtroom in Nuremberg and heard the charges read aloud. The Nuremberg trials lasted until October 1946. The verdicts were not perfect. 12 defendants were sentenced to death. 7 received prison sentences. 3 were acquitted. The system was not designed to be perfect. It was designed to take the evidence, apply a legal standard, and produce a record. 1948, 3 years after the war ended. The United Nations General Assembly adopted the Convention on the Prevention and Punishment of the Crime of Genocide. Lemkin's word was now international law. His 12-year argument had a binding legal instrument behind it. 152 nations would eventually sign it. He had spent those 3 years lobbying personally, traveling, writing letters, appearing before committees. He was exhausted and sick and broke because he had spent every resource he had on the campaign. When the vote passed on December 9, 1948, a colleague found him sitting alone outside the General Assembly Hall crying. He said, "This is a gift to mankind. It took me 4 years after the end of the war. I paid for this with almost my health." He died in 1959. His obituary appeared on page 13 of the New York Times. He left no savings. His funeral was attended by 7 people. What he left behind was not nothing. The word he invented in 1944 is now in every language. The legal framework he spent his life arguing for is the foundation of every international war crimes prosecution conducted in the 80 years since Nuremberg. The International Criminal Court, established in 2002, prosecutes under exactly the architecture he proposed: individual criminal responsibility for systematic crimes authorized at the command level. Brenner's file, the 34 pages that Harkins delivered personally on December 27, 1944, is part of that record. What happened to that specific case in that specific queue is part of the archive. The archive exists. The record says this happened. This person did it. The law responded. Father Brendan Sheehan is still in Section 5, Row 11 at Henri Chapelle. White Latin cross. The same shape as the one on his helmet. Thomas Greer's wife kept the paper in the back of a Bible for 40 years. When she died in 1991, her daughter found it and read it for the first time. She said her mother had never mentioned it. She said she did not know what to do with it. She kept it. George Patton died on December 21, 1945. 12 days before the first anniversary of the incident in the ravine. Automobile accident. He never saw Nuremberg. He never saw the verdict. He filed the paperwork and drove back to his command post and finished the corridor to Bastogne, and then the war ended, and then he was gone. But what he said in that tent on December 23, 1944, is still in Harkins' diary. The convention will protect you all the way to the courtroom. And then it steps aside. He was describing exactly the architecture that Lauterpacht and Lemkin built, not because he had read their papers, because he understood something that most people only understand in the abstract. A civilization that applies its rules selectively does not have rules. It has preferences, and preferences are not law. The question he left unanswered in that tent, whether honoring the law for a man who ignored it is justice, or simply the price of remaining a civilization. At all, that question did not go unanswered at Nuremberg. It received the only answer a legal system is capable of giving. A verdict. Written down. Entered into the record. Whether the record is enough is a different question. It is the question Harkins was still sitting with when he wrote his diary entry. It is the question Colby was sitting with when he wrote that the law is not fast enough for the crimes committed against it. It is the question Lemkin was sitting with outside the General Assembly Hall in December 1948 when the vote passed, and he was crying, and he said, "This is a gift to mankind." And the gift was not justice. The gift was the instrument. The gift was the word and the law behind the word and the court behind the law and the record behind the court. The gift was the architecture. Whether any specific man stands in a specific courtroom and hears a specific verdict depends on the cue and the evidence and the witnesses who survived, to give statements, and the lawyers who stayed late enough to read 40-page memos, and the aides who stood at desks until files were logged and receipted. It depends on people doing the correct thing. Not the satisfying thing. The correct thing. Patton walked out of the tent. He drove back to his command post. He finished building the corridor. The corridor arrived on time. It saved thousands of lives. It shortened the war. He carried the question with him for 12 months until he didn't have to carry it anymore. The question is still here. It did not go with him. Maybe that was always where it belonged, not answered, carried, by the people still building the corridor. We began with a priest walking into a ravine. We watched an SS officer read the law carefully enough to use it as a weapon and then stand in a canvas tent and hold it out toward the man who had every reason to destroy him. We watched two lawyers build an argument in a JAG office in February 1945 that became part of the foundation of Nuremberg. We watched Raphael Lemkin invent a word that took 12 years to become law and buried him on page 13 of the New York Times with 7 people at his funeral. 4 parts. 4 people. 1 question that none of them could close. What happens to the people who do the correct thing when the correct thing is not enough? Here is what happened to each of them after December 23, 1944. And here at the end is the detail that almost nobody knows. Captain William Harkins delivered the 34-page file to the JAG office on December 27, 1944, and stood at the desk until it was logged and receipted. He spent the rest of the war at Patton's side processing the decisions of a man who made more of them per day than most commanders made per week. He wrote his diary entry about the tent on December 25th, Christmas morning, sitting in a requisitioned farmhouse 30 miles from Bastogne, while the corridor Patton had built was still holding. He wrote 1 paragraph. He ended it with a sentence about not knowing whether what he had witnessed was justice or simply the price of having laws at all. He kept the diary for the rest of his life. He never published it. His family donated it to the Patton Museum in Fort Knox in 1987, 43 years after he wrote it. A researcher found the relevant paragraph in 2003 and cited it in a footnote. That footnote is the reason this story exists in the form it does today. And Major Arthur Colby returned to Chicago after the war and went back to federal prosecution. He never talked publicly about the Brenner file or the legal argument he built with Lauterpacht. He handled homicide, fraud, and conspiracy for 22 more years before retiring in 1968. His personal papers at the University of Chicago Law School contain 1 reference to the JAG work, a single sentence in a letter to a colleague written in 1961. The hardest cases are not the ones where the evidence is weak. The hardest cases are the ones where the evidence is perfect and the system is not fast enough. Harold Lauterpacht was appointed to the British delegation at Nuremberg in 1945. He drafted significant portions of the crimes against humanity count in the indictment. He was knighted in 1956. He died in 1960. His work on individual criminal responsibility under international law is still cited in every major international tribunal operating today, including the International Criminal Court, which opened its doors in 2002 in The Hague. 42 years after his death, his name appears in rulings dealing with crimes committed on 3 continents. Raphael Lemkin attended the Nuremberg trials as an observer watching the legal framework he had spent 12 years arguing for finally receive a courtroom large enough to hold it. He spent the next 3 years in a campaign of personal lobbying so total that it consumed everything he had. He traveled on borrowed money. He slept badly and ate irregularly and wrote letters to delegations at all hours. When the Genocide Convention passed on December 9, 1948, he was outside the hall and he was crying. He died 11 years later with no savings. 7 people at his funeral and a word in every language on earth. The word he invented is now prosecuted under in The Hague. His face appeared on a commemorative stamp in Poland in 2011. A park in New York City was named after him in 2018. These things happened 59 years after his death. He did not know they were coming. he would not have cared. He wanted the law. He got the law. The rest was noise. As Thomas Greer went home to Macon, Georgia in September 1945 after 4 months recovering from the wound that took a portion of his lower intestine. He got a job. He raised a family. He never spoke publicly about the ravine. The one time he mentioned Father Sheehan was to his wife the night before their daughter's baptism in 1951, 7 years after the ravine, and what he told her was not about dying. It was about the way Sheehan turned back to look at him in the last seconds he had. Not at the rifle, not at Brenner, at Greer. The last thing Sheehan gave him was his full attention. Greer told his wife that he had thought about that almost every day for 7 years and had not yet found a way to explain what it had done for him. His wife wrote it down that same night. She kept the paper in the back of a Bible for 40 years. When she died in 1991, her daughter found it and read it for the first time. This is the detail most accounts of this story do not include, and it matters for a reason that will become clear in a moment. The broader legal legacy of what Kolbe and Lauterpacht built in that JAG office in February 1945 is not abstract. It is operational, and it is measurable. The architecture they developed that a man's pre-capture conduct was not shielded by his post-capture legal protections, that systematic crimes could be prosecuted at the command level rather than trigger by trigger, became the structural foundation of every significant international war crimes prosecution conducted in the 8 decades since Nuremberg. The Yugoslavia Tribunal, established in 1993, prosecuted 161 individuals under exactly that architecture. The Rwanda Tribunal, established in 1994, prosecuted 93. The International Criminal Court, which became operational in 2002 and has jurisdiction over genocide crimes against humanity and war crimes, has opened 31 cases involving commanders and heads of state across Africa, Asia, and Europe. Every single one of those cases rests on the legal principle that Lauterpacht articulated in a 40-page memo that almost nobody read because it was 40 pages long and there was a war on. Now, the Geneva Convention itself was revised and expanded in 1949 to close the gaps that cases like Brenner's had exposed. The 4 1949 conventions and their subsequent protocols created explicit protections for categories of persons that the 1929 instrument had not fully addressed, and crucially, they created explicit criminal liability for grave breaches of those protections. The conduct clause that Brenner had exploited the gap between what the law protected and what it punished was closed, not eliminated, narrowed significantly. The lawyers who closed it were building on the argument that Kolbe and Lauterpacht had made in February 1945 in a JAG office in a building that no longer exists in a file that is now in an archive in Washington. What's here? 196 nations have ratified the 1949 Geneva Conventions. It is the most widely ratified international treaty in history. More nations have signed it than are members of the United Nations. Father Brendan Sheehan's name is on a white cross in Section 5, Row 11 at the American Military Cemetery at Henri Chapelle in Belgium. The cemetery contains 7,792 graves. Of those, 288 are chaplains or medical personnel, protected persons, killed while performing protected functions during the Northwestern European Campaign. Their cases form part of the documentary record that fed into the 1949 revision process. Their deaths were not wasted in the legal sense. They became evidence. Evidence became argument. Argument became law. That is either consoling or insufficient, depending on what you need from this story. Both responses are legitimate. The story does not tell you which one to have. Now here is the detail that almost nobody knows. It is not dramatic. It does not change the outcome. But it completes something. Thomas Greer's daughter, after finding her mother's paper in 1991, did not know what to do with it. She kept it for 12 years. In 2003, the same year that the researcher found Harkin's diary entry in the Patton Museum archives and cited it in a footnote, Greer's daughter read a newspaper article about the Henri Chapelle Cemetery that mentioned Father Brendan Sheehan by name in a list of chaplains buried there. She had not known his name until that moment. Her father had never said it. What he had told her mother was the priest, the photograph, the Latin words, the way he turned back. No name. She drove to Henri Chapelle from her home in Georgia the following spring. Section 5, row 11. She brought her mother's paper, and she read it at the grave. She did not know what the Latin words her father had heard were. She asked the cemetery chaplain if he could tell her what words a Catholic priest would say at that specific threshold, when there was almost no time left, and the most important thing was that they were said before the time ran out entirely. He told her. She said she recognized them, not the words themselves, but the shape of them from the way her father had described hearing them in the snow in 1944. She stood at the grave for a long time. Then she folded the paper her mother had kept for 40 years and placed it at the base of the white cross. A cemetery attendant found it and gave it to the administration office. It is now in the Henri Chapelle records. A piece of paper with a woman's handwriting on it, describing what her husband told her the night before their daughter's baptism in 1951, about a priest in a Belgian ravine whose last act was to give a dying man his full attention. That paper traveled from a farmhouse bedroom in Macon, Georgia in 1951 through 40 years in the back of a Bible, through 12 more years in a drawer to a grave in Belgium in 2004. 60 years after the morning it was trying to describe. Here is why this story is worth the 90 minutes you have spent with it. It is not a story about a battle. No territory changed hands. No strategic objective was secured. What happened in that ravine on December 23, 1944, did not affect the outcome of the Battle of the Bulge. What happened in the holding tent 31 miles away did not change the timeline of the war. The corridor to Bastogne arrived on schedule regardless. Thousands of lives were saved regardless. What the story is about is what civilization costs to maintain. Not to build, not to defend from external threats, to maintain, from the inside. On the days when the person the law is protecting is the person who violated it. On the days when honoring the rule requires extending it to someone who never extended it to anyone. On the days when doing the correct thing and doing the satisfying thing are not the same thing, and you have to choose. And Patton chose. Colby chose. Lauterpacht chose. Lemkin chose for 12 years, running on no money and no recognition, and 49 dead family members, and the absolute conviction that the word he had invented needed a law behind it. Each of them carried the question Harkins wrote down on Christmas morning. 1944 is honoring the law for a man who ignored it justice, or simply the price of having laws at all. None of them answered it. All of them paid it. Yeah. From a ravine in Belgium, where a priest turned back to look at a dying man, instead of at the rifle pointed at him, to a convention signed by 196 nations, that is still the most widely ratified international treaty in human history. From a 34-page file delivered to a desk on December 27, 1944, and stood over until it was logged to a courtroom in The Hague that has been open for 23 years and is still open now. This is what the correct thing looks like. Not the satisfying thing, not the fast thing, not the thing that feels like justice in the moment when justice is what you need. And the correct thing. Filed, logged, receipted, carried forward by people who understood that the line between civilization and its alternative is not held by armies or treaties alone. It is held by the individuals who choose on the specific day when the choice is hardest to do what the law requires, even when the law does not feel like enough. The priest knew that. He turned back to look at the man in the snow instead of at what was coming. That is the whole story. That is all of it. Everything else is the record of what people did with what he left behind.